welcome everybody to session number 3 of what we've called Classroom Courtroom, and really has evolved more into courtroom. It gives you just a minute on how we got here and why we're here. I'm very fortunate that over my career here, I've gotten to know a lot of the judges, Judge Hirsch and Judge Scola, are friends as well as wonderful jurists and dedicated public servants. And everyone that I was in touch with recently has sort of bemoaned the fact that people aren't getting into trial. And there's a lot of reasons for that. Judge Scola has written a very good article, which we enclosed last time. But this group is actually a very eclectic group. There's law students here, there's law practitioners, there's paralegals, there's people from around the state. And the idea here is to make everybody more familiar, more comfortable, and more dedicated to the practice of law in Florida. We have here in the Southern District and in Miami a long history, a very, very brilliant history of lawyers and judges who are known around the country for the excellence of our trial bar. And you all know many of the people who have made it that way. Great trial lawyers, civil trial lawyers, criminal trial lawyers, appellate lawyers. And the same is true for the judiciary. The Southern District is well known, and our circuit court judges here. We're very fortunate. Some of you may know my sister was on the bench for 19 years, and she's now doing other things immediately. So it occurred to me maybe 6 months ago, along with Chief Justice Fred Lewis, retired from the Florida Supreme Court. Fred and I have been friends for our entire careers. So I picked up the phone and called 15 or 16 lawyers and judges and told them what I thought we could do to make everybody more familiar with the trial procedures, trial law, the anatomy of trial, make everybody more comfortable in getting into court, getting back into court, and not to make it so intimidating. Of the 16 people that I called, everybody said yes. There wasn't anyone who hesitated or said on their back, well, I've got to check. So we have 16 people, lawyers and judges. The chief judge of the 3rd DCA at Scale is on this committee, the former chief justice of the Florida Supreme Court. Hey, welcome. So for today, this is the format here is really a roundtable. It really is interactive, and it's not intended to be terribly structured. It's intended for people to not only learn a little bit, but to express their interest in and things that they'd like to see easier or better. So to accomplish that today, we have a 90-minute session. We have Judge Hirsch and Judge Scola, and they are going to give you not just views from the bench, but things that they've seen over their very distinguished careers. And that's going to take up this session. The next session, you may, as a housekeeping matter, you may want to know is March 19th. We have a number of people here from the first 2 sessions that continue to come back. March 19th is here. And then we have another session in Key West, which is going to be special on May 28th. We have a restaurant there for programs, light refreshments and dinners, and whoever wants to come down to Key West. So we've limited the program in attendance to about 20, so we could all be here with each other. And in terms of the subject matter, it's really about the anatomy of a trial, getting into trial. Our first session was building for practice, which is very well attended, because you're not going to have any trials if you don't have clients and cases, right? You're going to sit there and do nothing. Trust me, I did that. I mean, that's how I started out. You wouldn't believe it. But that first session went very well, building your practice. We'll do that again towards the end. But now I want to turn us over to Judge Scola, who has a PowerPoint, and Judge Hirsch, and then we'll leave time at the end for questions or socializing or whatever you all want to do. Okay, so Judge Scola, it's all yours. I'm going to
Thank you. Good evening, everybody.
Good evening, Judge.
It's kind of a weird setup here where I'm talking with my back to my audience, so I apologize. I was a trial lawyer before I became a judge. In my 15 years as a lawyer, I was a prosecutor and a criminal defense attorney, and tried over 100 felony jury trials. 75 as a prosecutor and over 25 as a criminal defense attorney. And back in those days, from 1980 to 1995, when I became a judge, if you said you were a trial attorney, okay, you say, well, how many trials have you had? Person would be easily to say, well, I've had 25, I've had 75. Sometimes you have people of the previous generation of lawyers that before there was no fault insurance, where all those car accidents went to jail, would have hundreds of jury trials. And the jury trials are declining at a pace that is very troublesome. And that's why I have called my presentation Trial by Jury, the 1% solution, because back, what happened, Alberto?
Sorry about that.
Okay. So if you look back in 1962, and this is in federal court, but I'm sure the numbers in state court are not that different in terms of, the decline. You had only 50,000 civil cases filed, and over 5,800 went to an actual jury trial, 11.6%. Okay, by 1990, you had 290,000 cases filed and less than 5,000 trials of 1.6%. And it's kind of been consistent from 2010, 0.97%, 2016, less than 0.6%, so it's way less than 1% of civil cases go to trial. And the numbers in criminal court are not much higher, maybe 3% of criminal cases go to trial, when back in the early 80s, 15% of the cases went to trial. And there's a lot of reasons why that has happened. Some of them are good. A lot of companies are entering into arbitration agreements to avoid the cost of litigation. Now, if there's two big companies having a deal together, they want to put an arbitration clause in their agreement, they're kind of, on equal footing. It's really not anything unfair. But now you see, if you have a cell phone, okay, or the AT&T, or buy a refrigerator, like almost every contract that you have requires you to do arbitration if there's some dispute and not go to trial. So even though there's some good reason to have arbitration, that's one of the not so good reasons why the jury trials have declined. Again, in the last 25 years, there's mandatory mediation in all civil cases. Again, I think that's a good thing. Mediation allows the parties to decide on their own how they're going to resolve the case. You don't have to put it in the hands of six people that they don't know. You don't have to worry about appeals. You can, you can be the decision maker in deciding how your case is going to be resolved. And of course, the costs of litigation have skyrocketed. And again, there's going to be arguments from both sides, whether you're a civil plaintiff or a civil defendant, but it's clear, especially in federal court, that more cases are resolved by summary judgments or motion to dismiss. And usually they're not resolved by summary judgment in favor of the plaintiff. It's usually the defense that is winning those. So, yeah, but that's the reality of life. And because of this, as I said, my generation, if you ask anybody, they probably had 50 to 200 jury trials. If you ask a bunch of lawyers that are 40 to 55, how many jury trials they have, maybe they've had 10 or 15. If you have people who are 25 to 40, they're lucky to have 2 or 3. And so you have to decide, okay, if you are going to be a litigator or a trial attorney, because there are two very different things. A litigator is someone who sends out requests for interrogatories and requests for production and takes deposition. A trial attorney goes to court on a Monday morning and picks a jury and has the case decided by the jury. But here's the dilemma, okay? No case is ideally ready for trial. There's always, no matter how much you prepare, you're my expert. And I told him 6 months ago that this case was going to trial, and now he booked a cruise, and I got to convince him not to go on this cruise. Those things really happen, okay? And no case exists that doesn't have some problems to worry about. Okay? There's no perfect case. So if you're looking for a reason not to go to trial, you will find it in 100% of your cases. Okay. And when you don't go to trial, when you blink, okay, and you settle the case, okay, because you're afraid to go to trial, okay, you're going to cost your client. Okay. Either the plaintiff, you're going to take less money than the plaintiff really should get. If you're the defense, you're going to have your client pay more money than he should really do that. Okay. And so what's happened over the years, okay, it's because less than 1% of the cases go to trial, then most lawyers say, well, I'm going to prepare this case as if it's one of the 99% that's going to settle. Because why am I going to spend all this extra money for experts? Why am I going to take all these depositions when I know if I just do a little bit, I can settle the case, okay? And the problem with that is, yes, you may settle the case, but you're settling for less than it's really worth. And if the case ends up going to trial, your client is not going to get what they want, and you're going to embarrass yourself in front of the court and in front of juries. So what you really need to do is prepare every case as if it's that one case, that 1% of your cases that's actually going to go to trial. Because I guarantee you, if you do that, even when it comes time to settlement, the other side is going to see how prepared you are, how aggressive you are, how ready you are, and you're not ready, they know you're not going to blink, okay? Because when you blink, it's costing your client money. Okay? Again, I'm not saying you should be obstreperous and not settle a case when a reasonable settlement is made. But too many times people are settling cases that shouldn't be settled. And if you want to be a trial attorney, I'm so glad to see all of you here. Okay, this is a great way to learn in some ways about being a trial attorney. But to me, and I taught 22 years at the University of Miami Litigation Skills Program. And Judge Hirsch has taught for many, many years at the law schools, okay? To me, trying a case is like riding a bike. So imagine you've never seen a bike, you've never ridden a bike before, and somebody says, look, you can take all the time you want in the world to learn about riding bikes. You can watch videos, you can hire Lance Armstrong to give a demonstration. You can take as long as you want, a week, a month, or 10 years, okay? No matter how much time you prepare, I will bet my life that when you get on the bike, you're going to fall over. Because until you get ready for that sensation, okay, you can't handle it. And being a trial lawyer is like that. The only way to get good at trying cases is to try cases, okay? And so you can't be afraid to go to trial because you haven't had a trial. You can't be afraid to go to trial because you've never done it before. So what can you do? You can go to these kind of seminars. There's seminars where you actually go and perform opening statements and cross-examinations, direct examination, closing arguments. I would suggest we have in the federal courts a volunteer lawyers project where you can go on our website. There's a list of cases, and most of the time the judges don't list them until they are past motion to dismiss, until they're past summary judgment, and they are ripe and ready to go to trial. They're crappy cases, okay? There's a great chance you're probably going to lose the case, okay? But the judges will appreciate that you came in. Rather than having some crazy pro se person trying the case, they'll be happy that some young lawyer is coming in, and they'll give you the opportunity to stand up and pick a jury and do cross-examinations, direct examination, and closing arguments. There's another way to get into court to try a case so that when you have a real case that's very much more meaningful, you're going to be more prepared. So some people say, well, you know what? I'm going to decide which cases are going to go to trial and which cases are going to settle. And I will say this, and I'm sure Ira and Judge Hirsch will agree. Okay, if you have the ability to look at your list of cases and to pick out which one's going to go to trial and which ones are going to settle, you have an ability that no one else in the history of the world has ever had. Okay, my good friend Michael Hansman was a judge, and he now does mediations where he charges $25,000 a day. Okay, and I can't tell people how many people have said, "Oh, I had a mediation in front of Judge Hansman. It was an impossible case. It was never going to settle, and he settled the case." Okay, now part of it is that due to his skills and force of nature that he is, but the point is, you don't know. Okay, and so again, if you are going through your cases and saying, "Okay, I'm going to pick which one I'm going to really work on, and which one I'm not," you're really not doing you or your client any services. So we already talked about doing that, and again, if you prepare these cases like it's going to go to trial, it's not, you're going to get the value of the case even if the case settles. I would recommend to everybody here to read a book called A Civil Action. It's a true story about a cluster of children outside of Boston, Massachusetts, who had, I think, leukemia, and they couldn't figure out why. It was like way beyond the number of kids that had leukemia. And the reason I want you to read it is the plaintiff's lawyer in that case, I think his name is Jay Schlickman, okay, was the kind of lawyer that if somebody had a case that was worth $50,000, he would go overboard and work up the case and do everything so he can get his client a settlement of $100,000. And that case shows how much his efforts over years and years and years to get these people the relief against all the odds taking place. And so, because I think one of the things lawyers do is they get the case. Every lawyer, most lawyers, okay, have a house with a mortgage. They have health insurance they have to pay for. If they have kids, the kids might be in private school. They have all these expenses that come up. Okay, then they have a pool of cases that are sitting there. And you can look at this case and say, "Oh, this is a PI case. I think I can get $150,000 for it, and it's not set for trial for a year and a half." And all of a sudden now it's January 13th. I just, paid my taxes. It's a new year. I don't have any money. Let me call the adjuster and see what I can do. And they offer you $75,000. It's like, I need the money, and just go. And so let me ask you a question. So if you had a case where the plaintiff was a construction worker, he got hit in a car accident, broke his leg, had a rod put in the leg, missed 2 months of work at $10,000 a month. So he got $20,000 in lost wages. He had $50,000 in medical expenses, and he may surgery in the future to remove the rod or not. How much is that case worth? Anybody have any idea? Huh?
Policy limits.
What's the policy? What's the policy? 10,000 could be a hit policy. The point is, you guys are mostly lawyers, okay? I'm a judge. I've been a judge 30 years. I have no idea what that case is worth. Ira Leesfield probably has a good idea in his mind what it's worth, okay? But the construction worker has no idea. Okay, so when you tell him when he comes in, "Oh, I'm going to get you $150,000 for this case, and now you need to pay your kids' tuition or your health insurance is going to expire unless you pay the money," it's like, and they're offering you $75,000. You call your client in, "Well, your deposition didn't go as well as we thought," and and then he takes the $75,000. Because how does that client know what the case is really worth when none of us know what it's worth? And I think a lot of lawyers get away with settling cases for less than the worth, because the client, not that the clients are ignorant, but it's very few people know the true value of a case. Okay, so I want to start that. That was kind of like a background about why we need to have trials, why you need to be prepared, the best possible way to try cases. So I'm just give you a few tips. I mean, if I were teaching this course, it would be a week-long course. There's so many different things you need to do before the trial and during the trial, and different skills you need to develop along the way. So I'm trying to pick a few major things that I think are important to think about, And you can walk away from here and have something concrete to look to when you have some cases. Okay. Number one, okay, start at the end. What do I mean by that? Okay, your case, okay, is going to be determined by the jury instructions. Okay, most of the lawyers don't even look at jury instructions until like, the judge is like, hey, where's the jury instructions? They're already in the trial and they're not giving the jury instructions. Okay, you should be doing that before you file a case. Okay, because the jury instructions tell you what elements you need to establish for each of your causes of action. Once you know what each element is, then you say, okay, what document do I need to establish that element? What witness do I need to establish that element? Okay.
Move these folks in. Move. So you can see that. Yeah.
And so, again, it's almost counterintuitive to go start at the end when you're at the beginning. Okay, and again, this goes to at the very beginning of the case before you file. But a lot of times you're going to be getting a case even shortly before the trial. Okay, so you got to make sure the person who filed it, filed the right claims. Make sure you know what summary judgment rulings. Sometimes there's partial summary judgment rulings that may affect certain outcomes. You got to know all that before you start the trial. Okay, and getting back to about the trial lawyer versus the litigator. I have not had a trial as a lawyer in over 30 years. I was a judge for 30 years. I've never had a civil trial as a lawyer. When I was a judge, today's January 13th, I would have lawyers come in. Judge, my case is set for trial on May 15th. It's a 2-year-old case. I know you said there's no forgiveness. But Mr. Jones, who was the lead lawyer on this case, just left the law firm. And even though I've been working on the case with him, there's no way I can be ready for trial in May. It's like, wait, I have all of February, all of March, all of April. I can tell you it's been hundreds of times where people come in and no, this trial set months from now. There's no way. And again, this may sound arrogant. And as Milton Hirsch, my good friend Marilyn Millian, who's a great prosecutor and a judge, a TV judge, several years ago, I was talking to somebody. I said, well, that person is arrogant. And she said, well, no one knows arrogance like Bob Scola. So this may sound arrogant to you. But if you came to me today on Tuesday and said, hey, Judge, we want to hire you to do this civil trial next Monday, okay, that you've never seen before, but the case has been prepared, I would do it. Okay, and I would do, and if anybody watched me, you would never know that I've never tried a civil case. You would never know I came in, last week, and I would do a good job, and so would Milk, and so would Ira. Okay, but there's so many lawyers. It's like they don't want to be there. They don't want to be in front of the jury, and they think about ways not to be there. And you cannot be one of those people. Okay, next, very, very important. Okay. Develop a theory of the case, a theme of the case. And it should be something simple that you can say in 1 or 2 sentences, okay? And then once you have your theory of the case, once you have your theme of the case, that's going to drive everything else you do, all of your other decisions, okay? Your partner says, I want to put on Ira Leesfield as a witness. Well, wait a minute. How does his testimony move the ball forward, knowing what our theory of the case is? Okay. Sometimes you have a witness saying, "Oh, this person's going to hurt you," but when you look at what you're trying to really establish, you may not want to attack them on cross-examination just because the other side is putting them on. Okay, so, and your theory drives everything from, and again, don't have a theory of the case on Sunday evening when the trial is starting on Monday morning. This is something when you get the case come in. There was a fabulous trial attorney, Irvin Gonzalez, who had a trial in front of me many years ago, and it was two brothers who his dad bought them. They were young men in their early 20s, and he bought them a chicken kitchen franchise. And part of the franchise agreement required them to have $1 million in liability insurance, and so they did not buy the liability insurance. One of their drivers hit Irvin's client on a motorcycle and his leg was amputated. So they sue Chicken Kitchen, the franchisee. I always get those two confused, right? It's franchisee. But then there's two young kids with the value of the franchise is almost nothing. So he sued Chicken Kitchen, the franchisor. Okay. And so, if I try to explain to you between a franchisee and a franchisor, it's very hard to with a group of lawyers. Okay, even judge, like I messed it up. So to try and explain it to a jury is even harder. So this is how his opening statement. Folks, this is a case about Big Chicken, okay, is responsible for the actions of Little Chicken. Okay, and like he didn't have, he eventually put on expert witnesses to talk about what a franchisee and but like he just boiled the case down to a very simple thing that they had to show that the Big Chicken controlled Little Chicken in so many different ways that they became responsible for Little Chicken, and he ended up getting like a several $1 million verdict for that by making it very simple. Everybody thinks, like if you ask most trial lawyers, like, what's the best part of your repertoire? Oh, I give the greatest closing arguments. So everybody's like, wants to be very proud of their closing arguments. I don't think I've ever met anybody who says, you know what, I give the best opening statements you've ever heard. Okay. And I think too many people, so people like think all the time about their closing argument, and not that they don't spend any time, but I don't think they understand the importance of it. Because in polling of jurors, almost 2/3 of jurors who were polled after the trial say that the initial impression that they had of the trial after opening statements never changed during the trial. Now, part of that may be that the evidence was overwhelming, that they heard an opening statement and just kind of went along with that. But part of it is, it's like if you are looking to buy a house, and you come to me and say, oh, Judge Scola, I'm thinking about buying this house. I would like your opinion about it. So I go over and I look at it and I say, if you look at the other houses in the neighborhood, they're kind of like run down. It looks like this neighborhood is not really kept up as well as you want. And I walk through and I say, see that stain up there? You probably have a leaky roof. And, I don't like the way that the house is set up. And the person would say, oh, thank you so much for that advice. I really appreciate it. If they ask you to come to your house that they just bought, and say, hey, Judge Scola, I'd like you to come and look at my house. Tell me what you think. Well, you're in a crappy neighborhood, your roof is leaking. It's like, hey, this is my house. What are you doing? Okay, and it's the same thing. Once the jurors, adopt, in the opening statement, the position of one party or the other, when you as a lawyer are attacking that position, it's like you're attacking the juror. Because wait a minute, well, that's my opinion that you're attacking. So spend time making sure that your opening statement convinces the jurors that you should win the case. It's a very, very, I think, underestimated part of the trial. And again, that's the time that you set forth your theory of the case and make sure that that theory of the case is consistently presented through all the other evidence and witnesses in the case and in your closing argument, so it all ties together. All right, next. Remember, a trial is performance art. Okay. Yes, you need to put on the legally required evidence and witnesses to meet your legal requirements to establish all the elements, but you need to do it in a compelling and interesting and entertaining way. Okay. And again, sometimes you have civil cases that are business disputes with lots of documents and emails. And again, you may have to introduce, I'll give you a couple of examples. Okay, so I was in the trial, and for some reason it was important for one side to prove that these two people had a very close personal relationship, friendship outside of the business relationship. And they introduced 500 emails between them over a course of 2 years. Okay, when the one of them would say, "Hey, Steve, you know, it's great to see you this weekend and the kids. You know, how's your wife doing? Blah blah blah." And so that's important. That, and then you introduce another one, and then another one, and then you get to the 50th. I mean, this everybody knows these people had a friendly relationship, but and I would call the lawyer's sidebar, and I said, "Okay, what are you doing?" I said, "All those other emails or text messages are in evidence. Okay, you can refer to them and close if you want, but you're boring the jurors. Going, you've already established that point. Okay, the same thing with bank records. Same thing with chain emails where there's like a string of emails, you know, over 2 months, and instead of like just hide, look, introduce all of them. Okay, I'm not saying don't introduce the evidence. Okay, introduce all of them, but the trial is you're highlighting to the jury those few emails that are important, that establish your elements, that establish your theory of the case. Don't bore the juries. Okay. Very important. Talk about that. Okay. As a lawyer, you are the director of the production. You are not the author of the production. Okay. Your job as an attorney is to maximize the impact of favorable evidence and to minimize the impact of unfavorable evidence. Attorneys who create evidence or create testimony or hide or destroy evidence get disbarred or worse. Okay. So what do I mean by that? Something happens in this room and there's a trial later on. And I'm the lawyer in the case. And for whatever reason, it's important to my case to emphasize to the jury that there were lots of people at this presentation. So it's okay. So I could get the witness to say, well, isn't it true, okay, that most of the participants were crowded together in the room and there were people that couldn't even fit in the room? It's like, yes, that's true. Okay. So, and that is true. Okay. And you're creating the impression, wow, this was a big turnout. Okay. Or you could say, well, isn't it true that there were only 25 people there? Okay. That's also true. Okay. But it creates a different impression. And that's the difference between getting involved in obstructing justice, okay, and suborning perjury, and being a good trial attorney. You're not getting people to change facts. You're emphasizing those part of the facts. Okay, so let's say you on direct, you bring out the fact that everybody was crowded in the room and there were people couldn't even fit in the room. If on cross-examine they want to bring out, hey, isn't it true there are only 25 people? Yeah, okay, yeah, it's fine. But put the burden on them to see, you know, what the other side of that equation is. And again, don't exaggerate things because it's going to end up biting you in the butt. Every witness is a time bomb waiting to explode. What do I mean by that? I don't care how many times you prepare a witness. I don't care how much you've gone over the testimony with them. If you leave them on the stand long enough, something that you've never heard is going to come out there that's going to destroy your case, or it's usually not something helpful to you. So when you put again, it's also part of your presentation, and you want to put it on in a compelling, interesting way. So you don't want to drag things on anyway. But just remember, like every second that witness is standing, tick, 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 tick. Okay, get them off before that bomb explodes. Another important thing: how do you impress the jurors with your effectiveness, your knowledge, your skill? Because your credibility as a lawyer is way more important than you can ever imagine. I had a case as a prosecutor, young prosecutor, my first homicide case. It's a traffic homicide where somebody ran a red light, hit a car and killed a person. And it was at like Elm Street and Maple Street. And there was only one independent witness who was standing there. And he said, yeah, I was standing on Maple Street and the car came from my left and hit, the car. Well, unfortunately, he was standing there, but it was the Elm Street or the other street. So of course the defense said, oh, you were on that street, then that's the street that had the green light, not the red light. Okay, and he explained, why he just mixed up the names, but he definitely, clearly told the jurors that the car that went by me from my left is the one that had the red light. And the jury convicted them. I spoke to the jurors afterwards, and I said, well, I guess you believe that witness in spite of, that mistake. He goes, well, we weren't sure if we believed him, but we definitely believe you. Okay, so it's important that the jurors believe you. So how do you get them to believe you? Okay. When you say, okay, I want to show you, the bank statement from April of 2024, and you look, you can't find it. Okay, or worse, you say, let me show you the bank statement. That's not a bank statement, those are telephone records. Okay. I mean, I had a criminal trial where the prosecutor was all these recorded conversations, and all the jurors had just binders like this, all the transcripts. The prosecutor would say, okay, I would like to go to page 37, line 18. Okay, jury, everybody there? Okay, play the thing. Start listening to it. I'm looking at 37:18. I go, whoa, I don't see that here. It's like, oh, hold on a second. And he's like looking around. He goes back to his, his table. Oh no, it's page 84. It's like not even like the next page or the previous page. I mean, he's an idiot. Okay, and he lost the trial. They had this many recordings, and half of them were video recordings of these guys planning to do this robbery, and they were caught at the scene with guns to do the robbery. And they're found not guilty only because the guy was an idiot, bumbling around. He got all the evidence in. Okay, but it's not just getting it in; it's how you present it to the jury. Okay, and the way that you are prepared and show the jurors you're prepared is incredibly important. I think I'm going to do another presentation in the future about how to introduce evidence. But when you go to introduce a piece of evidence, every judge watches a trial with varying degrees of attention. Okay. I mean, we've had trials. I tried over 100 cases. I used to get so mad when there'd be an objection and just go, rephrase it. I think clearly we're not paying attention. So I've always tried to pay attention as a judge. Okay. But even judges who kind of pay semi-attention, when they know that you're going to introduce a piece of evidence, they know that they have to listen to make sure that you have asked those 3 or 4 predicate questions for that exhibit. So you have the judge's attention. Okay. So first of all, if you want to introduce this mouse for whatever reason, okay, then you would start off by saying, well, sir, were you at this presentation? Yes. And did you use a mouse during this presentation? Yes. All right. Let's say it's in a bag. Let me show you exhibit, 1A. Okay. That better be a mouse inside of that bag. Don't open it up and go, oh, that's the microphone. Like your questions leading up to the introduction should let everybody know, okay, this exhibit is going to be the mouse, and the judge is listening. Okay, and let's say it's you have to show that 3 different predicates. Okay, and you ask one, and then you let me ask you about something else, and you wander around, and you go back, and then you ask 2. And then you wander around for a few minutes and you go back and ask 3. Well, you lost the judge's attention during the time you kept wandering off. Okay, even me who was paying attention, it's hard, it's hard for me to wait a minute. Did he ask it or not? And I know if I let it in and the predicates weren't established, I'm going to get reversed. And if the guy or woman knows what they're doing, they can just redo the predicates in 30 seconds and get it in. So sometimes I sustain an objection to exhibit that they may have asked all the predicates. They're wandering around, you get lost. Okay, so when you're handling exhibits, have the actual rule of evidence you're using. Okay, to get it in front of you, so if there's an objection that's overruled, Judge, can I see what side? Well, look, here's the rule right here. There's 3 things that I have to establish. I just asked these 3 questions, so it comes in. And that hopefully will convince the judge. Also part of handling exhibits. Most courts today have digital display systems and want you to use those, but more importantly, you want to use them. Okay, how many people here read the newspaper every day, or a newspaper, either online or nobody? Zero, like has a piece of paper that they folding over, right? If you're getting the news, you're on your iPad or your computer getting it. We're used to getting all our information in a digital format. Okay, so if you have people from this world on your jury, they're used to getting their information. So don't be one of these, oh, I'm old school, I like walking around with the paper and having them hand it down. No. Okay, use the digital systems that are available to you. And most judges, if you know you have a trial coming up, you contact their chambers the week before or 2 weeks before and say, hey, we have a trial coming up. Can I have my IT person, or sometimes you're the IT person? Can I come by and bring your laptop, whatever it is, connect it, make sure it works? Okay. I mean, I was here talking to Alberto yesterday to making sure I wasn't here, but I sent it to him Sunday. I was calling him. I came up early to make sure, because I don't want to stand up here in front of you. I'm not going to get paid. Okay. I'm not going to lose the trial, but I don't want to be embarrassed because the equipment doesn't work. Okay. You guys have a lot more to lose when you're in a trial and your digital evidence is not working. So make sure it works. Okay. Another important thing. This goes to that 99% versus the 1%. Okay, you take a deposition. Number 1, you want to know what this person has to say. Number 2, maybe they're not going to be around at trial and you'll have to use their deposition. But number 3, you may want to impeach this witness at trial. Okay, and you have to remember, and again, this is another hour-long presentation I can do just on how to properly impeach a witness, and maybe we'll do that later this year. Okay, but you have to remember that when you impeach a witness from a deposition, you have to read the entire question and the entire answer. So let's say you're in a case where you're defending somebody who hit the plaintiff's car, and the speed of the defendant's car at the time of the accident is important. And so at the trial, the witness says, oh, I think that the defendant was going 50 miles an hour at the time of the accident. So you pull out the deposition, and you've got to ask the question, well, how fast was the defendant going at the time of the accident? And they said, well, let me think about it. He crossed the center line like 2 or 3 times. Then he swerved onto the sidewalk and almost hit a woman walking her child. Then he came back on the street and hit the plaintiff's car. I would say he was going 20 miles an hour. Okay, so you can't just say, isn't it true in your deposition, you said he was going 20 miles an hour. Okay, if you're taking that deposition and you get that answer and you don't think, wait a minute, might want to impeach them someday, you need that. Your next question should be, all right, ma'am or sir, I just want to know at the time of the accident, how fast was the defendant's car going? Oh, it's going 20 miles an hour. Right now, you can take that one question and that one answer to impeach them when they say it was going 50 miles an hour, and you don't have to listen to them talking about driving on the sidewalk. And also, if you're going to impeach them, make sure you accurately read exactly the question and the answer. Otherwise, you're going to be impeached. Okay? Isn't it true? You said on this, you said, we were asked this question again, and they go, no, because you didn't read it accurately. So make sure, again, it goes back to the preparation, but also during the trial. Okay. As we talked about, every case has weaknesses. What are your weaknesses? Okay, you got to look at your own case's weaknesses, because you know the other side is going to do that. And then you have to identify them, and then you have to have a strategic decision with you and your trial mates. Okay, how are we going to handle this? Are we going to try and neutralize it? Are we gonna embrace it? Are we gonna reframe it? And you have to be the person, okay, who brings it out to the jury. Now, again, maybe there are times where you think this moron on the other side of the case is probably not gonna bring that out. Let's not say anything, and hopefully it'll slide by without anybody on the jury finding out. But most of the time, you know, your weaknesses are going to be brought out, so you have to anticipate them, and you be the person to present them in your way to the jury to diffuse. Again, remember, you're not hiding evidence, you're not destroying evidence, you're minimizing the impact of evidence that's not favorable to you. Finally, we're almost. Prepare a draft of your closing argument before the trial. And then, you know, of course, you're gonna have to tweak it based upon what happened in the trial. But remember, you have a theory of the case, you have a theme of the case, and all of those things you gotta think about, because when you give that closing argument, okay, when you are presenting your case, you want to think about, how am I going to use this in closing? In fact, that's one of the things I often ask lawyers when they say, Judge, we want to introduce this piece of evidence. Okay, what's the relevance of that? And that, okay, sir, let's assume we're in closing argument. Make your argument to the jury right now in front of me about this piece of evidence. Well, what do you mean? I go, well, you want it to come in, so you say it's relevant, so tell me what you're going to tell the jurors about it in your closing argument. Half the time, well, I can't tell you. Well, then it's not coming in. Okay, but you need to talk, you know, to think about your closing argument, because it is a very important part of the case. And to me, there is nothing worse when you have rebuttal argument for you to get up, and obviously you're going to take notes while the other side is doing their argument. Right down. The worst thing you do is get up and say, well, Miss Jones said this, and here's my response to that. And Miss Jones said that, and here's my, and no, you should have your entire rebuttal argument written out and organized, so it's in your organization and of course, if during Miss Jones's argument, you want to respond to that, and go back to your presentation and put in your response within the flow of the argument that you wrote. Don't let them control, you know, the pace and the chronology of your rebuttal argument. Okay. And again, no case goes as smoothly as you hope it will go. There's always things happen that are unexpected and unanticipated. You know, one of the skills of a trial attorney is going on the fly, trying to figure out, you know, something came out of left field. Maybe the judge makes a horrible ruling, okay, which we sometimes do, that you weren't anticipating. And you're there, you may win the appeal, but like, you're still going to want to win the trial first. Okay, so you always have to be prepared to adapt for things that are unanticipated, and don't get flustered by it, don't get frustrated by it. Pivot accordingly, think clearly, slow down, pivot accordingly. That's it. Oh.
Those words of wisdom, and if you really, if you want to read another book besides one Judge Scola recommended, read Judge Hirsch's book called The Shadow of Justice, which is excellent also. We're very fortunate to have Judge Hirsch and Judge Scola here today, and there's going to be more. This Judge Hirsch is going to address basically jury selection, which I think is the hardest part of any case, because you have the least amount of control over what that juror may blurt out when you say, do you believe in the system of justice? You know, can you be fair? You have no idea what they're going to say. Do you believe in the tort system? So Judge Hirsch, you're on, and what we're going to do, because each session is an hour and a half, is the next session we're going to go specifically into things like opening statement. Judge Hirsch is going to do jury selection, anything else he feels like. But we're going to go sort of item by item in the anatomy of a jury trial. And we're going to, how do I advance? And Judge Hirsch will kick it off. Now, Bob, thank you for those excellent remarks and insight from all of your years as a judge.
All right, do you folks out there, we have PowerPoint here, do you want to move in here, so you,
Yeah, there's room.
there's room, at least for the short feet. Yeah, the short feet. Yeah, right here.
Because the PowerPoint is on this screen.
There's room, the chairs right here. Put a couple of chairs right here. I can put some chairs right here.
Move up, Dave.
All right, if you ask Ira Leesfield, if you ask Judge Scola, if you ask anybody who's tried a lot of cases, it is impossible to overstate the importance of jury selection. And the reason I'm choosing to speak about this is I knew I would be on panel with Judge Scola. He's a United States District Judge. That's like playing for the Los Angeles Dodgers. And I'm a state court judge in the criminal division. That's like the Lansing Lugnuts of the Michigan single, So, but in federal court, they don't do attorney conducted jury selection. It's a rarity. In state court, it's bread and butter, whether you're doing criminal or civil, and you simply cannot overstate the importance of attorney conducted jury selection in a state court case in Florida and in the overwhelming majority of state systems. Now, jury selection is a misnomer. We do not select juries. God selects the venire, and we get to get rid of a few of them. It would be wonderful if we could select juries. I would show up in front of me on Monday and say, Judge, you said we're going to select juries. I got 6 people out in the hallway. I owe them all money, Judge. They'll know what to do. Okay, that's not how it works. Jury selection is the only part of trial that has 2 separate phases. There is the voir dire of the panel, and then there is the exercising of what we call challenges or strikes. These are 2 very, very different skill sets, and it's not uncommon for someone to be good at one and not as good at the other. All right, so let's take them one at a time. The first section, we're going to talk about jury voir dire. Now, voir dire is a Norman French corruption of the French. If you speak French, you know that vrai dire is to say the truth, to speak the truth. All right. When the Vikings came, they were the Northmen, the Norsemen, the Normans. They conquered and occupied the part of France that still bears their name, Normandy. And they adopted French ways, and they tried to speak French, but they spoke it poorly. And they said voir dire, which is incorrect, but when in 1066 they conquered England, the last time England was successfully conquered, they brought it with them, and we use this expression even today. There are a number of contexts in which we voir dire. If the opponent calls an expert witness, say, Judge, I want to voir dire on this credential. Under 90.702 or in federal court under 702, that's voir dire. If there's a child witness, the judge will likely voir dire on the competence of the child. Bobby, do you understand the difference between telling the truth and telling a lie? If I say Bobby's shirt is white, is that the truth or is that a lie? If I say Bobby's shirt is blue, is that the truth or is that a lie? Right? That is voir dire. But what we're talking about today is the voir dire of the venire. Venire from the Latin venire, I will come, meaning the group of people who responded to summonses, who are coming to participate in the jury trial process. Everything I'm going to tell you today is exactly the same, civil or criminal, makes no difference whatsoever. In state court, federal court, they don't do this stuff, not very much, right? Typically, a trial begins when the judge tells the bailiff, go get the venire, go get 30, 40, 50 people, however many we can fit into this court, sitting in the gallery. And they're the people from whom we will select, or more accurately, deselect a jury. We used to refer to them in the old days as veniremen, but I think nowadays we usually say venire persons or venire members, all right? Typically at the beginning, the judge will ask the members of the venire qualifying questions. Does everyone here speak English? Is everyone here a US citizen? Is everyone here 18 years of age or older? Does everyone here reside in Miami-Dade County or whatever county your trial is in, and so on? The judge should probably not go far beyond that, although many judges like to talk. Not me or Judge Scola, but many judges like to talk. Really, this should be left to the lawyers once we get past the issues of competence. All right. Now, what is the purpose of voir dire? Every judge takes a blood oath. I am sworn to tell you that the purpose of voir dire is to pick a fair and impartial juror. I will go straight to hell if I don't tell you. All right? Now, all I can tell you is if I ever need a lawyer and you want to be my lawyer and you want to pick a fair and impartial juror, I don't want you for my lawyer. Okay? I want for my lawyer somebody who will identify and eliminate from the jury those voir persons who are most likely to return the verdict that we don't want. I want a lawyer who will use voir dire to cultivate the jurors' respect and trust. I want a lawyer who will try to educate the jury in voir dire and dispose the jury favorably toward the lawyer, his or her client, his or her case, and his or her outcome of choice. All right? In state court, the general rule is you are afforded ample time, great latitude in terms of time to conduct your voir dire. As long as you are not repetitive or wholly irrelevant, it is very hard for me to shut you down. Right? If you do have an instance where a judge tries to cut you off in voir dire, you're probably going to have a good issue on appeal. What you should do is go back to the office that night, type out a list of every question you would have asked if you had been permitted to do so, and a lot that you wouldn't. And do a notice of filing, file it with the clerk of court the next day, so that if you do lose this trial, you've got that issue on appeal, because Florida law heavily favors attorney-conducted voir dire. So it is very difficult for you to be shut down on the basis of time, which is, and as Judge Scola was saying, there is no judge in Florida who cannot tell you the number of acoustical ceiling tiles in his courtroom, lengthwise, widthwise, and on the bias, because you were up there droning on and on and on and on and on. All right. Now, I had the great good fortune to have a wonderful, famous professor who's long since dead by the name of Irving Younger for the course in evidence, and he used to give a lecture called The 10 Commandments of Cross-Examination. There are no 10 commandments. There's certainly no 10 commandments of voir dire, jury voir dire, but there's some things to think about. Here's an important, right? We're going to go through about 6 or 7. Don't ever pick a jury alone. Don't ever pick a jury alone. Have your trial partner, your paralegal, your secretary, your friend, your relative, anybody sitting at counsel table. Why? Because your hands will be empty. You will not be holding a pen, a pencil, a piece of paper, or anything else. Your hands will be empty as you talk to these jurors. And I know a wonderful trial lawyer, Ira Leesfield knows her too, who actually tells jurors, I don't think you have to tell them this, but I think you have to understand it. She gets up and says, this is a conversation, not an interrogation. I don't think you have to say that. You can if you want to, but I think you have to have it in your mind. And I always explain to young people something perhaps you'll understand in your context. Imagine that a nice young lady is sitting at the bar and a young man walks into the bar, and what's he going to do? He can't help himself. He'll walk up to her and say something stupid. It's what we do. Okay. He walks up to her and says, hey, did you go to Georgetown Law School? And she says, yes, I did. Now imagine him at that point going, hang on a second. Went to Georgetown Law School. Got it, great, okay. And so what are you doing now? I work in the state attorney's office. She works in this, okay. Now I'm willing to assume that a lot has changed in the 100 years since I last tried to chat up a girl in a bar, but that hasn't changed. That man's going home alone. He's going home alone, okay? If you wouldn't do it in that context, don't do it here. You're fucking at it. Don't take notes. The person sitting at the table will take notes for you. If possible, have someone who's not a lawyer sit with you. Now, that's not always possible. It may be your trial partner, and then that'll have to do. But a non-lawyer will actually hear the answer the way the denial person intended it. Whereas a lawyer will be filtering it through the sweet and sour meatballs that we made out of your brains when you went to law school. So if possible, all right, try to memorize the denier person's names. If you're not good at that, you can't memorize 30 or 40 or 50, then memorize 15 or 20. And if you can't do that, memorize 8 or 10. And don't memorize 8 or 10 in a row. Memorize 2 over there and 3 over there and 3 over here and 2 over there. So it looks like when you're calling on them that you've memorized the whole room. All right. And unless the judge tells you, now there are some judges who will say, counsel, do not address them by name. I don't get it.
Even in their last name?
Yeah. Yeah, I had a federal judge shut me down.
You said juror number 22 or something?
Yes. I had a federal judge, I spent the lunch break, I memorized 200 names. I was young then. I was young, yeah, before it all turned to petrified wood. And I'm up there going, Mr. Smith, Mr. And the judge, do not address them by name. Okay, most judges will permit you to do so, and you should do so.
Last name will.
Last, yeah, don't do me, yeah, last name, yes, okay. Alternate between asking questions of the venire as a whole and asking questions of a series of individual venire person, all right? So you might stand up and say, for example, ladies and gentlemen, anybody here ever served on a jury before? Anybody here ever been on? Oh, Mrs. Jones, you've been on a jury. Was it a civil one like this, or was it a criminal jury? It was a criminal jury. So I bet they talked to you about the difference between the burden of proof in a criminal and a civil case. Can you help me? I'm going to ask everybody some questions about that. Can I count on you to help me with that? And then ask individual questions, and then go back to a group question. Alternate between group and individual. Never, ever voir dire in order. Juror number 1, what color is blue vitriol? Juror number 2, what color is blue vitriol? Juror number 3, don't ever do that. Because what happens is the jurors over there fall asleep because they're not entitled to. And the jurors here, as soon as they've gotten the color blue vitriol right, they'll fall asleep too. All right. Don't ever do that. Bounce around the room. Look, understand something. They didn't ask to be here. They feel very uncomfortable. This is a strange environment for them. They don't know each other. They don't know you. They know you're a lawyer, so they think you make more money than they do, even though if you're in the state attorney's office or public defender's office, you don't make more money than anybody, but they think you do. You have to put them, it's up to you to put them at their ease and to try to get them to be a little bit less defensive in court. That's your responsibility. Don't fear the bad answer. Better to hear it in jury selection than to read it in the verdict. Roy Black told me that the first time we had co-defendants, and I've never forgotten. Okay? I'll give you an example from criminal practice, but it's exactly the same in civil. It makes no difference. In most criminal cases, the jury will not learn that your client has prior convictions. There are, however, certain circumstances where the jury will learn that your client has prior convictions. And if that's the case, for goodness sakes, bring it out in jury selection. Don't fear the bad answer. Better to hear it in jury selection than read it in the verdict. Ms. Jones, I want you to know something. You never say my client, but Mr. So-and-so. If he's older than you are, he's Mr. So-and-so. If you're older than he is, he's Bob or Joe or whatever. Was convicted of a crime in the year 2014. It wasn't this case, unrelated to this case. It has nothing to do with that. But he wanted me to mention it. He wanted me to tell you so that you would know. Now, I'd like to think that has nothing to do with this case, but you tell me what you think. Bring it out. If somebody says, hey, if he was convicted, you need to know that. You need to know that, right? The flip side of that is exploit the good answer. Your adversary will strike that venire person, but you may be able to use it to reach others. Here again, forgive me, I'm going to use an example from criminal practice because it's most important I know. In the old days, we used to try marijuana cases, right? And every once in a while, you'd be doing voir dire, and someone in the panel would say, I don't think I could convict somebody for marijuana. I just don't think I could do that. Now, that person's going to be stricken. He can't follow the law. The law is marijuana is a crime, or it was in those days. So that person's going to be stricken. But if you're the defense attorney, don't just walk away from that person, right? Mr. Smith, you say you couldn't convict someone for a crime. Is that because there are so many studies that indicate that young people who get convicted for marijuana come out of prison hardened criminals? Is that the reason you feel that way? Is it because so many states now are starting to do away with laws against marijuana? Is that why you feel that way? I don't care why he feels that way. I just want to say all these things. And I'm going to keep saying all these things until the judge says, counsel, move on, which the judge will, and promptly, but squeeze it till it's dry. Okay. goes back to something Judge Scola said. There is an unwritten rule, you'll never find a citation for it in the law. Most judges will allow you 2, maybe 3 declarative sentences at the beginning of your voir dire. The law is voir dire is questions, just questions. If you try giving a speech, the judge will shut you down. But if you have 2 sentences or maybe 3 carefully prepared, you can squeeze that in if you move right on to your questions afterwards. And what goes there? Your theme of the case goes there. Do not get up and say, good morning, ladies and gentlemen, and they don't respond, and you say, oh, come on, good morning. I will beat you with my gavel if I catch you doing it, okay? Don't get up and start saying, this is what we call voir dire. It's from a Norman French corruption of vrai dire, which is French, as you know. Don't do that. These are the first words out of your mouth. And when Judge Scola said how important opening statement is, that's because in federal court, those are the first words out of your mouth. You don't get voir dire. In state court, you do. These are the first words they're ever going to hear out of your mouth. Make them count. So if the theme of your case is whatever it is, start with that and then move from that to a question that somehow relates to that. You can't give a speech, the judge will jump on you and say, questions, counsel, questions, just question. Okay. These people are not lawyers. These people are not lawyers. The things that are clear to you are not clear to them. We speak plainly and clearly, right? There is a host of dumb analogies that lawyers have invented for use in jury selection that have the sole effect of causing jurors to think that you're weird. All right? So if you're the prosecutor in a criminal case and you say, now, ladies and gentlemen, all we have to prove is the elements of the offense. It's like a peanut butter and jelly sandwich. We have to prove bread, peanut butter, and jelly, but we don't have to prove Swiss cheese. Does everyone understand that? No, nobody understands that. Nobody has any idea what that has to do if you're trying to explain reasonable doubt. Let's say you're on a plane that's supposed to land in O'Hare and the pilot says, well, there's a heavy fog, I think I can land. Would that be a reasonable? Unless this case is actually about a plane landing at O'Hare, don't ask that question. Ask them in plain language exactly what you need to know. Ask them what you want. Don't do that goofy stuff. It just confounds and confuses. All right, so let's say you've gotten through your jury voir dire. The plaintiff goes first, then the defense. We've got through all of that. Now, so what? What are we going to do with it? Yes, we've tried to achieve the goals of gaining their confidence, disposing them towards our case, disposing them towards us. But yes, now we've got to actually select or deselect a jury, all right? Now, as I imagine you all well know, there are the second step of the procedure is the exercise of what we call challenges or strikes. Those are synonymous in this context. The easy kind is cause challenges. Anyone who cannot follow a particular law that must be applied to the trial or has had a life experience that makes it impossible or difficult for that person to be fair and impartial is subject to being stricken for cause. So in my example of the man who said, I don't think I can convict somebody for marijuana, I just don't think that should be considered a crime. That someone is subject to being stricken for cause. He can't follow the law. The law says you have to consider that a crime. And if the person's proved guilty of it, you have to convict it. Very common in all kinds of cases, criminal and civil, somebody will say, well, something happened to my sister and I don't think I'd set it aside. I don't think I'd put it out my mind because it's very similar to what you're telling me that this is about. That person is subject to being stricken for cause. If he can't or she can't be fair and impartial, the wiser question, the law is clear, judges are told, the law tells us if we have a reasonable doubt about somebody's ability to be fair and impartial, that person is to be stricken for cause, okay? That's a cause challenge. Cause challenges are the easy ones. In addition to cause challenges, you get peremptory challenges, challenges for which no reason need be given. You get a fixed number, depending on the nature of the case, you get a fixed number. There's no limit on the number of cause challenges. You had a fixed number of peremptory challenges. And then the question is, how do you know who to strike? How do you decide who to strike? Now, here's the problem with peremptory challenges particularly, okay? There is a history in this country, I don't know about other English language countries, but in this country of really ugly use of peremptory challenges. Clarence Derry, you may have heard, was one of the greatest trial lawyers in American history. Very great trial lawyer. After he retired, he wrote an article. He was retired, called "How to Pick a Jury," and it's just full of ethnic slurs, which is how he proceeded in this case. He said, always, if you represent the plaintiff in a civil case or a criminal, the defendant in a criminal case, never strike someone who has an Irish last name. Don't strike Jews or other agnostics, but people who are Scandinavian, you strike them. And he had a whole, laid out an entire sort of ethnic discrimination theory of jury selection. And this went on, this was going on as late as when I started trying cases, when Judge Scola started, Ira Leesfield started trying cases, this stuff was still going on. After President Kennedy was assassinated, and there was the trial, the most famous trial in America was the trial of the man who shot the assassin. And it came out that the district attorney's office in Texas had this memo that they passed around: do not put on your jury Jews, Negroes, Dagos, Mexicans, or a member of any minority race, no matter how rich or well executed. And people followed this stuff. This was done, this was widely done. This kind of discriminatory practice was the basis of jury selection for much of American history. It's offensive, but it went on. In a slightly later generation, I don't know if you knew, did you know Philip Corboy? You did? Okay, I'm not surprised. Philip Corboy was a really great plaintiff's personal injury lawyer, practiced principally in Chicago. The legend was, and I was told this on pretty good authority because I went to school with his son. He knew a cab driver who'd been driving a cab in Chicago for years and years and years. And he used to hire the guy to sit next to him in jury selection. And if the guy, if the person on the veneer was Mr. O'Brien from Back of the Yards, or Mr. Goldberg from Rogers Park, the cabbie could say, he votes Democratic, he's in favor of this, he's against that. He could come up with a whole series of things. And allegedly, on that basis, Mr. Corboy exercised his strikes. How true this is, I don't know, but it may have gone on. We didn't have anything better in those days. In your generation, you will have something that it's not better, it's at least different, and that is this. Yours will be the first generation in the history of trials where you will have too much data rather than not enough. Now, I don't say too much information, but I do say too much data. Because if you have a lot of money, you'll have an IT person sitting with you in court, and if you don't have a lot of money, you'll have your 14-year-old cousin sitting with you in court with a laptop. And the minute you get somebody's name, nowadays, you can go on that laptop, and if your 14-year-old cousin is as skilled as every other 14-year-old in America, in 2 seconds flat, he's going to get into all kinds of social media. And the things you learn about it. Now, a lot of what you learn from social media is boring and irrelevant. We put all kinds of mindless stuff about ourselves in social media, but some of it is not. And the smallest thing can matter. So if your cousin tells you, this guy just posted in social media that he's got a new bumper sticker on his car that says, "Save the key, dear," that's a very different juror than the one who has a new bumper sticker on his car that says, "Insured by Smith & Wesson."
Yeah.
Those are very different jurors, right? And you're going to be using that a lot. Now, as far as the law goes, Article 1, Section 16 of the Florida Constitution guarantees the right to an impartial jury. In 1984, the Supreme Court of Florida did something that was we saw it coming, but it was still revolutionary. Hadn't happened in federal yet, all right? State versus Neal, jurors should be selected on the basis of their individual characteristics and should not be subject to being rejected for these kinds of appalling ethnic characterizations that were going on in those days. All right. That's 2 years before the US Supreme Court caught up to that. And they said, because there's every litigant, whether it's an individual or a corporation of the state of Florida, every litigant in Florida has a right to a race an impartial jury. That means an impartial jury selection process. So the process must be neutral as to race, ethnicity, gender, and so on. Lawyers cannot engage in that kind of appalling conduct that we used to see as a matter of course. All right. Now, this is wonderful from an idealistic standpoint. It's wonderful, creates a problem, right? The idea of peremptory challenges is you're entitled to remove jurors without being obliged to give or even have a reason for doing so. But we've just changed the law in 1984 to say you don't have to have a reason, but you can't do it for a wrong reason. Those are two valuable principles that are very difficult to reconcile. And they are the law in the state of Florida, but they've generated a tremendous amount of jurisprudence in the attempt to reconcile them, right? The present state of the law, now we see this in criminal too often and in civil not enough, although there are a number of reported civil opinions in Florida that deal with Melbourne versus state. Melbourne versus state is the present state of the law as far as what happens if you believe that an attorney on the other side of your trial is engaging in invidious discrimination. And remember, it need not be overt foaming at the mouth invidious discrimination. It can be what people call implicit prejudice or implicit bias. Look, we're none of us perfect. And it may be that the lawyer on the other side of you is striking someone without even realizing that he or she has been tilting a little bit toward or away from a particular ethnic group or gender. When this first came out, we were very unwilling to use it as lawyers because we felt like we were calling opposing counsel racists. And you don't want to deal with fellow lawyers. You don't want to do that. But it's not that. That's not what you're doing. You're policing an important point, a very important constitutional point. So if you believe, if someone says, okay, Judge, juror number 16, no, I'm exercising peremptory, I'm striking him or her. If you believe that is based on race, ethnicity, gender, religion, anything of the kind, it's a three-step process. First, you must make a timely objection alleging that the person is a member of a specific racial, ethnic, religious, or whatever group. It need not be a historically oppressed group. It's as much a violation of Neal and Melbourne if you say, Judge, that Benire person is a Protestant white man, but I think counsel is striking him because he's a Protestant white man. That counts, all right? And at that point, you're asking the court, we say, Judge, I want you to inquire of counsel. I want you to ask for a reason for the strike. Now this, you say, but wait a minute, peremptory challenge, you don't have to have a reason. Now you do. Now you do. A facially sufficient objection under Melbourne is the only thing I know of in all of the law that shifts the burden of proof. A merely facially sufficient objection shifts the burden of proof. The burden of production now shifts to the proponent of the strike, the person who wants to strike that juror, to come forward with a reason that is neutral as to the characteristic you identified. So if you said, Judge, I object, juror number 16 is female, it must be a neutral reason as to gender. Juror number 16 is Hispanic, it must be a neutral reason as to ethnicity, and so on, right? If at stage 2, the reason is neutral, that is as far as the court inquires at step 2. But at step 3, the judge has to ask if the reason is non-pretextual, right? So if at step 2, the lawyer says, Judge, that Benire person has tattoos. And I think that people with tattoos always return plaintiff's verdicts. So I'm striking. Now, is that neutral as to race, religion, and so? It is. It's also ridiculous, but it passes step 2. It is neutral as to the factor that you raised. At step 3, the judge now has the very difficult decision to make. We use the word, is it non-pretextual? You know what that means? That means, is he telling a big fat lie? That's what it means. That's what it means, all right? Do I believe when he says he thinks people with tattoos always return plaintiff's verdicts and that's why he's striking this guy? Do I think he really means that? Or is that a pretext to get rid of women, Hispanics, blacks, Jews, white people, whatever? Right? Tough call for the judge at step 3. Right? Now, the jurisprudence in this area is vast, and I'm not going to launch into, we could spend an hour on this easily, right? But I want you to be aware of this, not only because you do have an obligation to police this constitutional principle as against attorneys with whom you cross swords, but also because they have an obligation to use it against you, and you need to be aware of it. I'm going to stop there, Ira, because otherwise we spend an hour on the law of Melvin. Okay?
Well, Judge, thank you both. Phenomenal afternoon. Before we leave, Sophie's going to do a group picture, but I want to give you, as I should, a preview of the upcoming. This is session 3, sessions 4, 5, and 6. Because we're really going to go through, and I think you all will enjoy it, specific areas of trial anatomy. For instance, putting on your witness on direct examination. Well, what could be more boring, you would think, in a trial than direct? It's not like the sparks fly in closing argument. Opening statement is said to be closing argument without the volume. You know, it's opening statement, closing argument, the same thing with different volume. So just to let you know what's coming, what's coming is vignettes. We're going to do some war stories and vignettes, and I can be as self-deprecating as I want. And I can tell you that when I was a young lawyer, about 24 years old, my very first case, I was with a great law firm with Bill Frappies, who was the toughest taskmaster ever to walk the face of the earth in terms of teaching young lawyers. He just intimidated you and wanted you to crawl under the table. But he picked me to go to trial and help prepare a trial with him. It was a head-on collision on the Florida Keys, a terrible case, and all the debris on this head-on collision was on the northbound lane. So one could assume that the collision was in the northbound lane. So Mr. Frady's taught me a little bit about how to practice law. I went to see some other trials. Quick story, a vignette of things that come. Direct examination. Mr. Frady says, opening statement, you make opening statement, and everything you say in opening statement, the collision was on the right side, the collision was in this lane, everything you say in opening statement, the next thing you do is call the most credible witness you have to build your credibility to back up what you just said, and that witness gets on the stand. And who's the most credible witness ever in a motor vehicle collision? The highway patrol guy, you know, with the hat, the brim, the gun, the belt, the badge, whatever they say goes, right? Smokey the Bear, right? Right. So they come. So Mr. Frady says, who'll be our first witness? I'm going to say that the defendant and the plaintiff wound up on the wrong side of the road. The defendant crossed the center line. That's our case. I said, yes, Mr. Frady. He says, make sure you get the highway patrolman there first, right after opening statement. I said, yes, Mr. Frady. And he said, okay. He made opening statement. It was brilliant. He said, call your first witness. I said, we called Trooper Jones. Looking around the courtroom, Trooper Jones, no Trooper Jones. There's a guy sitting in the back with a Hawaiian floral shirt, a pair of khaki pants, and he gets up, take the witness in. Now I'm trying to get the credibility of the uniform, you know, polished. And he said, Mr. Frady looks at me, he says, who is that? I said, I think that's our trooper. He said, you didn't tell him to wear his uniform? I said, Mr. Frady, how would I know to tell him to wear his uniform? I said, these guys sleep in their uniforms, right? He's always in his uniform. He says, I'm going to call the first witness, the guy with the floral shirt. I said, yes, Mr. Frady, you are. He said, 1 second here, we're getting a recess. And those are the things that never, ever appear anywhere. the stories, and I can embarrass myself all night long about things that you didn't know. How was I supposed to know that the trooper would show up in his Hawaiian floral shirt? So this is a preview of things to come. We're going to talk about your mistakes, things you do right, things you do wrong, things you wouldn't foresee, things you wouldn't know. So we've got a few more sessions and a lot of people interested in helping out. Many of you have been here before and are coming back. Please continue to come back. You get 3 CLA credits today, thanks to Carmen. We got it up from 2.5 to 3 in the Florida bar. I think it's because of Judge Scola and Judge Hirsch, but we got 3 credits for today. I think the program, you all are getting the gist of what we're trying to do, and that is to present information, insights, innuendo, and things that you might not hear, but for Judge Scola and Judge Hirsch. So the next time we're going to get into specifics of opening statement and direct and cross, closing argument, and everything in between.